Today's question comes from Waukesha, Wisconsin, and the reader asks the following. Can I open a checking account in the name of a trust if I am the only successor trustee while the primary is alive? So by primary, I think they mean the grantor, the creator of the trust, who's probably still serving as trustee. We have a trust in the name of my father. He is the primary trustee, and I am a successor trustee. He is gravely ill. Can I open a bank account to protect his assets from probate before he passes as a successor trustee? Do I have the power to do that? So that's the question in full. And the answer to this again comes down to you need to examine the trust document to see what powers it grants you as successor trustee. If you are the successor trustee but not yet acting, my initial reaction is that you likely lack the power to open this account. However, many trusts, such as the ones I draft, include provisions about what happens when the initial trustee, your father, is ill or incapacitated. Now for trusts I draft, there's often a provision stating that if two physicians say they're incapacitated, unable to act, then the successor steps in. So if your trust has a provision like that, it's likely you could trigger that provision and begin acting as successor trustee. In general, if you are the trustee, you likely have the power to open an account and move assets around, any assets already owned by the trust. Now, one thing to be aware of is sometimes people form a trust but they don't transfer the assets, like the title to real estate. Well, then you need to look and see if in your father's estate plan he executed a durable financial power of attorney. And if he named you as agent, the ones I draft often say that my agent may take assets and pour them into my trust plan. So for example, let's say there's a piece of real estate your father never retitled. It's possible you could act as his agent to retitle that piece of real estate into the name of his trust. If you get it into the name of the trust, then it would avoid probate upon his death. And it sounds like your goal here is to avoid probate on these assets, so you want to make sure that as many assets as he owns are all retitled or assigned into the name of the trust. I recommend working with an experienced estate planning and probate attorney to accomplish this because it sounds like you're on a very short timeline. Great question, and thank you for asking.